Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzelli & Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by DocketWise, an all-in-one immigration forms and case management solution trusted by thousands of immigration lawyers across the U.S. I really like DocketWise. It makes immigration applications easy by allowing the clients to provide information through simple online questionnaires that are shareable by text or email and available in multiple languages. Not only that, DocketWise provides a comprehensive group of case management features, including invoicing and calendaring, secure messaging, task management, and a lot more. You can learn all about DocketWise and receive a 10% discount on your subscription by heading to docketwise.com/immigration-review, so they know we sent you. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. Vital immigration news this week. Former immigration judge Jeffrey Chase, who like former IJ Elise Shugal is very active in the roundtable of former IJs and BIA members, wrote me directly after my interview with IJ Shugal to inform me that contrary to what Judge Shugal stated during our interview, the roundtable indeed possesses a roundtable. It sits in Judge Chase's residence and is both round and, quote, mid-century modern, end quote. Judge Chase even sent a photo. Therefore, please note the correction to Judge Shugal and I's conversation last month. And of course, check out the discussion in your podcast feed if you haven't already had the chance. I have no non-citizen wins to report this week, just 6 interesting cases. Enjoy! Off we go, with Ayanian v. Garland, published by the Ninth Circuit on April 3rd, 2023. This case is about motions to reopen and mediation. Mr. Ayanian is from Armenia. He was forced to serve for 2 years in the USSR's military in the late 1980s and the early 1990s. Then, following the USSR's collapse, Armenia went to war with Azerbaijan. Quote, after reading several newspaper articles about abuses and crimes against service members committed by military leaders, Mr. Ayanian refused to join the military and hid from the officers who came by his parents' house to recruit him, end quote. He fled to Russia proper and came to the United States as a non-immigrant visitor in 1996. He did not depart. Former INS initiated removal proceedings in 2000. He applied for asylum and related relief, albeit a few years untimely for asylum. The immigration judge denied all relief and protection, as did the BIA, and the Ninth Circuit affirmed a few years later in 2006. Mr. Ayanian then filed a motion to reopen with the BIA based on changed country conditions a few years later, which the BIA denied, and the Ninth Circuit affirmed that denial in 2015. Remaining in the United States, Mr. Ayanian filed a second motion to reopen based on additional changed country conditions in 2016. This time, the motion was based on the simmering conflict between Armenia and Azerbaijan over the disputed Nagorno-Karabakh territory, a long-standing dispute that would indeed erupt into a full-fledged war a few years later. But not yet, at the time of his second motion to reopen. The BIA denied that second motion to reopen, not least of which because it didn't see any, quote, reasonable probability, end quote, that the Armenian government, quote, might try to conscript a 47-year-old man into military service or punish him for not serving, end quote, all those years ago. The BIA also held that Mr. Ayanian had failed to establish materially changed country conditions since that 2002 removal order, as such motions to reopen require. The appeal of this second denial of the motion to reopen remained pending before the Ninth Circuit for 5 years. After about 5 years, Mr. Ayanian filed a motion to stay the appellate proceedings to seek alternative means of resolution. Seems like he was trying to adjust to lawful permanent resident status or perhaps consular process with a waiver through either his mother or his sister, who were both United States citizens. Still likely need to reopen and terminate proceedings before the BIA. But either way, Mr. Ayanian requested time to try, because these petitions, his sister's and his mother's, were not immediate relative petitions, and a visa wasn't yet available to him, even though the petitions had been approved many years ago. And the Ninth Circuit indeed stayed proceedings until May of 2022. But with nothing resolved by then, Mr. Ayanian filed another motion for a stay. And this one, the Ninth Circuit denied. Then, quote, at oral argument, Mr. Ayanian's counsel conceded that Mr. Ayanian's second motion to reopen lacked merit, end quote. Not great. Mr. Ayanian seems to simply want more time for his approved non-immediate relative I-130 priority date to become current so a visa can become available and he can try to get prosecutorial discretion. In this decision, the Ninth Circuit does not believe that this is an appropriate thing to try before a Circuit Court of Appeals. That being said, even with counsel conceding that that second motion to reopen was meritless, the Ninth Circuit briefly addressed the merits. With a changed country condition motion to reopen, quote, the critical question is whether circumstances have changed sufficiently that a petitioner who previously did not have a legitimate claim now does, end quote. Mr. Ayanian appears not to have made a case for this, so the court denied. Then, as to a stay or order for mediation, the, quote, requests not to rule on his petition until he successfully adjusts his status, end quote. Well, the Ninth Circuit said no. Quote, becoming a lawful permanent resident is a multi-step undertaking. Before a non-citizen can even apply for adjustment of status, the non-citizen must complete the difficult and lengthy process of obtaining a visa number, end quote. Indeed, if they even have a path. Don't forget that part. Often on the podcast, I'm talking about adjustment of status through petitions filed by immediate relatives, such as United States citizen spouses or children over the age of 21. But that's not what Mr. Ayanian is trying here. His petitions are not filed by immediate relatives, so he needs to wait in the State Department's very long line for such petitions to have their priority dates current. The court goes on to explain in detail the visa and preference category system that we all know and love, quoting prior precedent to state that, quote, to say that the visa process is complicated would be an understatement, end quote. Check out this discussion if you need a refresher, or if you need process language to quote in your Mandamus and Administrative Procedure Act lawsuits. As many of us know, depending on the visa category, quote, after a sponsoring petition is approved but before a visa application can be filed, a family-sponsored immigrant may stand in line for years or even decades, just waiting for an immigrant visa to become available, end quote. And only when current can a non-citizen then apply for an immigrant visa or a green card in the United States, a process which itself, as of the date of this decision, ranges from, quote, 13 to 23.5 months. End quote. That's once the petition is current. And of course, in many cases, quote, a pending application for adjustment of status does not confer lawful immigration status on an applicant, end quote, thereby potentially subjecting non-citizens with pending applications to removal proceedings, which, if began, will divest USCIS of jurisdiction over the pending application to adjust status. All of this is discretionary, and after Patel, likely unreviewable in federal court. Welcome to the jungle. All the more reason why the Ninth Circuit wasn't willing to stay appellate proceedings pending Mr. Ayanian's efforts to legalize his status by alternative means. Now, in fairness to Mr. Ayanian, he had been waiting for his priority date to become current since 2007, and it only recently became current. Probably the sibling petition, but I'm not sure. But the adjustment of status process before USCIS, if he's even eligible, can still take 2 years. And again, that assumes removal proceedings get terminated by someone. Now, also true, quote, the purpose of the Ninth Circuit's mediation program is to facilitate the voluntary resolution of appeals in order to reduce the court's workload and to offer parties an alternative to litigation to resolve their disputes, end quote. But Mr. Ayanian's case apparently isn't appropriate because, as his attorney conceded, the case in chief lacks merit. He's not seeking a resolution of his actual claim before the Ninth Circuit. Therefore, to the split panel, quote, "It is an abuse of our mediation process to use it for a purpose unrelated to resolving disputes and as a substitute for the issuance of a stay," end quote. That being said, of course, the executive, represented by Oil and the Department of Homeland Security, quote, "is always in control of a non-citizen's removal and may exercise its enforcement prerogative as it sees fit," end quote. But that's for the executive, said the court, not the judiciary. Let's see what the Supreme Court says with the Mayorkas memo this term, huh? Mr. Ayanian, therefore, lost his case. Here's some stuff from the concurrence and dissent. Judge Wardlaw concurred and dissented in part and would send the case to mediation, stating that Mr. Ayanian's, quote, "plea for mercy may have been more warmly received by other panels of our court," end quote. Shots fired. Judge Wardlaw takes a larger view of mediation, recognizing that its basic function is, quote, "bringing parties to the table," end quote, and as Oil stated at oral argument, might give Oil, quote, "a little bit more push," end quote, with DHS, its client. Nothing unique there about attorneys and clients, if we're being honest. Also, according to Judge Wardlaw, quote, "it is well known that our nation's immigration system is broken. It is calcified by decades of congressional inaction, destabilized by dramatic shifts in enforcement policies, and currently burdened by COVID-19-induced processing backlogs. Congress's repeated failures to update our immigration laws leaves non-citizens, advocates, and executive branch officials in an untenable position, forced to work around systematic pitfalls in this fractured system," end quote. Love dissent writing sometimes. As Justice Blackmun apparently said in 1989, also in a dissent of course, quote, "compassion need not be exiled from the province of judging," end quote. And that is Ayanian v. Garland. Next is Andrade-Prado Jr. v. Garland, published by the First Circuit on April 4th, 2023. This case is about aggravated felonies and particularly serious crimes. Mr. Andrade-Prado is from Brazil. He suffered a lot of trauma growing up. As an adult in Brazil, he was in a relationship with a woman, and shortly after their relationship ended, she accused him of rape. He was prosecuted and eventually sentenced to over 7 years in prison in Brazil. But less than 2 years in, while on a work release program, quote, he escaped from prison and fled to Panama and eventually entered the United States in August 2008 via Texas border crossing. A Brazilian arrest warrant was issued on July 13th, 2012, end quote. Wow. He started a new life in the United States. Married, had 2 kids, all U.S. citizens. Started a carpentry business, and in 2017 tried to get his Brazilian conviction expunged. That's possibly what tipped off ICE about him, and ICE arrested him following issuance of an Interpol Red Notice in 2019. Brazil wanted him back. In removal proceedings, he applied for asylum and related relief, as well as non-LPR cancellation of removal, voluntary departure, and somehow adjustment of status, which I imagine was summarily denied, as it doesn't appear he was ever inspected or admitted into the United States. More importantly, however, if Mr. Andrade-Prado's conviction is an aggravated felony, he can't get any of those things anyway. And rape is an aggravated felony at INA Section 11A43A. Might also be a crime of violence at INA Section 11A43F. Mr. Andrade-Prado argued that none of it should apply to him because the conviction occurred in absentia, and so it wasn't fair to punish him for it in immigration court. But to the immigration judge, the record showed that he was in fact present at the trial, and that he did in fact have an opportunity to put up a defense in Brazil. So the IJ eventually found the conviction valid and not violative of constitutional due process to use, and then concluded that it was an aggravated felony and denied all relief. The IJ denied cat deferral on the merits and the BIA affirmed. It wasn't quite so straightforward as what I just said, but that's the gist. Today, Mr. Andrade-Prado is in Brazil, having been removed pending petition for review. But that doesn't divest the First Circuit of authority to hear this case. And hear this case it did. So, was the conviction really obtained in absentia such that it is not fundamentally fair to use it against Mr. Andrade-Prado in removal proceedings? Alternatively, is the conviction, quote, nevertheless invalid for immigration purposes, either because the proceedings were fundamentally deficient, a travesty of justice, or because the trial judge was politically motivated, end quote? No. The First Circuit affirmed the BIA. Mr. Andrade-Prado argued that in Brazil, he was, quote, only present at the arraignment hearing and did not learn of his sentence until he eventually received notice via a letter sent to him in jail, end quote. And true, the Department of State's FAM will not hold a conviction against a non-citizen if the non-citizen did not have a, quote, meaningful opportunity to participate in the judicial proceedings, end quote. Remember that. Not only that, but the I-213 that DHS initially submitted in court actually said that the conviction occurred in absentia. To flip the usual argument on its head against I-213s, Mr. Andrade-Prado argued that, quote, because the information in a Form I-213 is presumed trustworthy, the immigration judge should have treated the form's characterization of his conviction as reliable evidence that his conviction was in absentia, end quote. LOL. The First Circuit didn't bite. Quote, the record supports the BIA's conclusion that petitioner was able to meaningfully participate in his Brazilian proceedings, and thus his resulting conviction was not in absentia, end quote. He was present, he had counsel, and he even had a witness testify in his favor. Now, as the Seventh Circuit held long ago in Esposito v. INS, there may be circumstances where an IJ is permitted to go beyond the conviction to ensure that use of the foreign conviction would not be fundamentally fair. But here, quote, no exceptional procedural infirmities existed in the Brazilian proceedings to justify disregarding his conviction, end quote. As to the I-213 thing, although DHS's amending of that I-213 following a conversation with Brazilian authorities may have been hearsay, hearsay is admissible in immigration court, and DHS is permitted to amend the I-213 where appropriate. That left Mr. Andrade-Prado's travesty of justice argument. He argued that the presiding judge in Brazil was biased against his family, and therefore the foreign conviction can't be used in immigration court. Whether this is even a possible argument in the First Circuit, or quite frankly anywhere, is far from settled, and so the First Circuit's entertaining the argument is something in and of itself. Indeed, the court states in a footnote that, quote, in the rare case in which the proceeding that resulted in the conviction was demonstrably a travesty, a parody of justice, the foreign conviction may be invalid for immigration purposes, end quote. So there's a chance and a standard. But it was not met here. Mr. Andrade-Prado did not submit reliable enough evidence or testimony to meet it. He therefore lost his case. His conviction is an aggravated felony and a particularly serious crime that bars him from all relief, and apparently he doesn't warrant cat deferral on the merits. Before getting to the next case, though, I have a thought. In this case, Mr. Andrade-Prado conceded before the IJ that if his foreign conviction was legitimate and valid, it was an aggravated felony and a particularly serious crime. So it wasn't at issue in this decision. And not to give a good argument away, but our firm has won on it before. A little reviewed portion of the aggravated felony statute at INA section 101A43 states that a foreign conviction will qualify, quote, for which the term of imprisonment was completed within the previous 15 years, end quote. Not only would that language appear to per se bar in absentia convictions, because of course the term of imprisonment is never completed with those, but it seems to me that it wouldn't apply in this case either because Mr. Andrade-Prado never completed the term of imprisonment. He escaped, remember? Don't get me wrong, a tough argument to swallow, but I don't see how it's avoided under the text of the statute. And that is Andrade-Prado Jr. v. Garland. While we're in the criminal realm, I wanted to mention this case very briefly. United States v. Henderson, published by the Third Circuit on March 29, 2023. Thank you, Lila Thompson out of Philadelphia, for writing to flag this sentence enhancement case that I missed last week. According to Lila, and quite frankly quoting the decision, quote, under Pennsylvania law, conspiracy to commit robbery does not constitute a crime of violence, end quote. No violent force required or attempted. This is just a conspiracy. Plus, it seems likely that the completed offense of Pennsylvania robbery can be committed recklessly, which after the Supreme Court's decision in Bourdain likely makes it not a crime of violence even if completed and not merely conspired to. That's an argument to be resolved conclusively in the future, but it looks like quite a few district court judges in the area have already so held. Good to keep an eye on, and again, thanks for making me aware of the case, Lila. And that, very briefly, is United States v. Henderson. We'll be right back after a word from our sponsors. This podcast is sponsored by Journey Business Plans. Journey is the leading business immigration plan writing company in the United States. 10 years. And they know immigration. Heck, they started as an E2 company themselves. Journey prides itself on its responsiveness and overall customer service, preparing business plans for E2, EB2 NIW, L1, EB5, and much more. If you don't yet know about Journey, and don't want to listen to just me, ask your colleagues. Or even better, try them out. Visit www.journey.com and use promo code REVJOURNEY30 for a 30% discount on your first business plan. That's REVJOORNEY30. Or click on the link in the show notes. This podcast is also sponsored by Capital Good Fund. Millions of families seeking to improve their immigration status face financial barriers due to the high cost of legal services. Nonprofit Capital Good Fund is working to make these resources available to all, especially those who would otherwise not qualify for traditional loans. Certified CDFI Capital Good Fund is partnering with attorneys to provide the financial services families need. They offer affordable financing with no closing fee or down payments for those working with attorneys to move their case forward and get attorneys out of the accounts receivable business. To learn more about the program, email immigration@goodfund.us or call 866-584-3651 and tell them who sent you. Moving on to a duo from the Fifth Circuit. First, Tobar v. Garland, published by the Fifth Circuit on April 7th, 2023. This case is about temporary protected status, or TPS. Ms. Tobar is from El Salvador and initially entered the United States under a different name, her birth name, without authorization in 1997. She was ordered removed in absentia shortly thereafter. I guess she was placed in removal proceedings and did not appear. But the country of El Salvador then received a TPS designation in 2001, following, I believe, a catastrophic earthquake in that country. If you were from El Salvador and in the United States at the time and during the times specified by former INS, you could get TPS. Even a removal order doesn't per se bar TPS, so Ms. Tobar, who may have not even known about her removal order, applied for it, and she received it. TPS, of course, is not a permanent immigration status. It's a weird pseudo-status that seems to be in a state of flux. But certain Salvadorians, like Ms. Tobar, have had it for over 20 years now. Quote, TPS, however, requires non-citizens to maintain a continuous physical presence in the United States for a set period of time. End quote. TPS beneficiaries may leave the country without disturbing their continuous physical presence if their absences from the United States are, quote, brief, casual, and innocent, end quote. I also believe that if TPS beneficiaries are going to depart the U.S., they should probably seek advance parole. And I also believe that they are rolling the dice by departing the United States, even with advance parole and TPS, if, like Ms. Tobar, they have a final order of removal. But Ms. Tobar did leave the United States in 2015. She quit her job and went back to El Salvador to visit her sick father, who it appears later passed away. She did not seek advance parole, it appears, because, quote, her TPS was not in her own name, end quote. And she was gone for a bit, 111 days. When she returned, it looks like DHS figured it all out and placed her in removal proceedings. She conceded removability, unsure on what basis, and instead sought to apply for TPS again in removal proceedings, which IJs do have authority to grant if, of course, the non-citizen qualifies. But in Ms. Tobar's case, the IJ believed that the 111 days had disrupted her continuous physical presence, which is required to obtain TPS. To get TPS from El Salvador, even though she had it before, in addition to the other requirements, the Salvadoran citizen must have been in the United States continuously since February 13, 2001. To the IJ, Ms. Tobar's trip was not brief, casual, and innocent, and was not of short duration, as required of 8 C.F.R. section 1244.1. So the IJ denied TPS after all these years, and the BIA affirmed. So it looks like Ms. Tobar has 2 removal orders now? Unclear about that. But to the Fifth Circuit we go. And just based on the averages of decisions discussed on the podcast, not the best place to go. But as an initial matter, the Fifth Circuit agreed with Ms. Tobar that the TPS phrase, quote, of short duration and reasonably calculated to accomplish the purpose for the absence, end quote, is not further defined in section 1244.1. So there's some leeway on what qualifies. But to the Fifth Circuit, that means that they need to defer to the BIA's reasonable interpretation of that phrase. In this decision, the Fifth Circuit saw nothing, quote, plainly erroneous or inconsistent with the regulation, end quote, in the BIA's analysis of Ms. Tobar's 111 days abroad. The BIA reasoned that the duration of Ms. Tobar's trip was not short or innocent, because although she had traveled to visit her sick father, the factual record showed that, quote, 1, she quit her job before she departed, 2, she was gone for 111 days. 3, she had waited 13 years since her father's cancer diagnosis to visit him. And 4, the evidence, contrary to what she said, indicated that his death was not imminent. He did not die until 2 years after her return to the United States, end quote. Looking at the record in totality, the Fifth Circuit didn't think the BIA was crazy. And that's it. Ms. Tobar, having undeniably gone to visit her sick father, lost her case, no longer has TPS, and very well might be removed. And that is Tobar v. Garland. Next is Elldakli v. Garland, published by the Fifth Circuit on April 4th, 2023. This case is about adjustment of status and jurisdiction. And I hate to say it, but I'm nearly positive that in 2023, I'm going to summarize this decision or something similar in every circuit. I've already mentioned similar holdings out of the 7th Circuit and the DC Circuit at a minimum in recent months. More are coming. All will likely come. Here's the 5th. So I'm going to try to be relatively brief with them as they arise. Mr. Elldakli appears to actually be Dr. Elldakli. Dr. Elldakli and his family sought to adjust to LPR status as a, quote, professional holding an advanced degree whose work is in the national interest of the United States, end quote. He therefore filed an I-140 petition, and with that petition pending, Dr. Elldakli and his family filed adjustment of status applications with USCIS. USCIS then granted those adjustment applications before even deciding the I-140 petition. Obviously a mistake, and not quite sure how that happens. 6 months later, USCIS denied the I-140 petitions and then served notices of intent to revoke the green cards. To be honest, I don't know what the substantive dispute was about. The decision doesn't say. I don't know anything about Dr. Elldakli, other than he's a doctor, he's from Libya, and he has a family. He sued USCIS in district court, asking for a temporary restraining order against USCIS from rescinding the green cards, and challenging the I-140 denial under the APA and Declaratory Judgment Act. But the district court held that it couldn't even hear the case under INA Section 242A2Bi. That was debatable before Patel. After Patel, it's becoming increasingly not debatable. In this decision, the Fifth Circuit affirmed that the court lacked jurisdiction. But hey, actually the Fifth Circuit didn't rely on Patel at all. Instead, the court held that USCIS's denial of adjustment of status isn't final agency action, because non-citizens, quote, may renew status adjustment requests upon commencement of removal proceedings, end quote. No mention of what happens if DHS decides not to initiate removal proceedings, but there you go. To challenge any agency's action under the Administrative Procedures Act, the agency action must be final. Similarly, for Patel and the INA's jurisdiction stripping provisions to apply, the agency action apparently must be final. So the same reason that Dr. Elldakli loses, failure to exhaust his administrative remedies, is the same reason that Patel apparently doesn't apply. A distinction without a difference for Dr. Elldakli, who still loses. In a footnote, the Fifth Circuit distinguished this holding from cases where a non-citizen cannot reapply for the relief he is requesting from USCIS in immigration court. But that's probably a limited exception. Judge Higginbotham concurred based on prior Fifth Circuit precedent, but thinks in reality the court should have the Patel discussion. Heady stuff. But really, and unless I'm missing something, the result is the same. Adjustment of status denial challenges in district court are dead or close to it in the Fifth Circuit. And if you think that's bad for litigation, wait until you hear what I've got for you next from the former Fifth Circuit. And that is Elldakli v. Garland. We conclude the week with Ponce Flores v. Garland, published by the 11th Circuit on April 5th, 2023. I hoped to never have to summarize this case in this way, because it's a loss, and it is a bad loss for non-citizens. And because our firm represented Mr. Ponce Flores in his ineffective assistance of counsel claim before the BIA, although not before the circuit court here. Mr. Ponce Flores is from Mexico. He is married and has 2 U.S. citizen children, one of whom suffers from severe autism. He supports his family financially, and through that support has ensured that his autistic daughter attends a special program for autistic children in Texas. Mr. Ponce Flores lives in Florida. As I always understood it, at least, one of the reasons that the rest of the family moved to Texas was for that special school, and Mr. Flores had to remain behind because his business, that he supports them with, is in Naples, Florida. He also has a bit of a criminal history, including a conviction for unlawful re-entry many years ago. He was placed in removal proceedings following a domestic violence arrest that did not result in conviction. He had been in the United States for a long time by that point, and an immigration court applied for non-LPR cancellation of removal under INA Section 240A-B, based primarily on the hardship that his removal would cause to his severely autistic daughter. According to Mr. Ponce Flores, at the immigration court level, his counsel was not responsive to his attempts to prepare for his case. According to Mr. Ponce Flores, counsel didn't return his calls and it appears neglected to submit some of the documents that Mr. Ponce Flores provided him. According to Mr. Ponce Flores, the attorney didn't prepare him for his individual hearing until very shortly before the hearing. The cancellation application itself was missing information, and perhaps most starkly, did not mention Mr. Ponce Flores' criminal history. There were limited autism documents submitted, little evidence regarding his support for his children, and limited evidence to show that he had been in the United States for the 10 years required of non-LPR cancellation of removal. No witnesses were called to testify. The immigration judge ultimately found the documents and testimony submitted insufficient. The IJ was particularly unhappy that the 42B application for cancellation didn't mention any of the criminal arrests or convictions, and denied on pretty much all elements possible. Quote, the IJ stressed that Mr. Ponce Flores had not submitted corroborating documentation such as affidavits from his wife or others, transportation receipts, wire transfers, or bank statements. End quote. Mr. Ponce Flores came to our firm on appeal. In addition to the appeal, and while we truly hate to do it, we filed a Lozada action against prior counsel, moving the BIA to remand proceedings based on a claim that Mr. Ponce Flores' prior counsel was ineffective. In addition to making the bar complaint that, for all intents and purposes, matter of Lozada unfortunately requires, we attached a lot of new evidence to our motion on hardship, 10 years continuous presence, good moral character, credibility, financial support, and the like. But the BIA denied our motion and dismissed the appeal. The BIA held that while Mr. Ponce Flores, quote, had identified deficiencies in his representation by former attorneys, he had not shown prejudice as a result, so as to have affected the outcome of these proceedings, end quote. The BIA read the record different than me. The BIA also held that even with the new evidence, Mr. Ponce Flores hadn't shown that his removal would cause extreme and exceptionally unusual hardship to his severely autistic daughter. This was mainly because, quote, he had lived apart from his family for over a year, He supported them financially, and his daughters would remain in the United States with their mother even if Mr. Ponce Flores was removed to Mexico, end quote. Plus, reasoned with the BIA, the state of Texas can provide for his autistic daughter's medical care. Through new counsel, Mr. Ponce Flores petitioned for review to the 11th Circuit. Of course, in the interim, the 11th Circuit and then the Supreme Court issued the Patel decision. And things went downhill from there. See, under Patel, if this was a straight petition for review of the denial of cancellation of removal based on a no hardship showing, the 11th Circuit almost surely could not review the issue. But that's not what's being challenged here. Mr. Ponce Flores is challenging the BIA's finding that he was not prejudiced by his immigration court counsel's ineffective assistance. That's a straight constitutional challenge. Non-citizens have a due process right to non-ineffective representation in immigration court, right? 11th Circuit precedent supports this. Well, to the court here, quote, "The failure to receive relief that is purely discretionary in nature does not amount to a deprivation of a liberty interest and thus cannot deprive a non-citizen of due process under the Fifth Amendment," end quote. Under certain other 11th Circuit precedent now affirmed definitively in this decision, because the non-citizen's, quote, "actual chances of receiving such discretionary relief are too speculative," end quote, an ineffective assistance of counsel claim tethered to that discretionary relief, quote, "is too far beyond the capability of judicial review," end quote. Affirming all of that here, the 11th Circuit seems to hold that no matter how ineffective Mr. Ponce Flores' immigration court counsel was, Mr. Ponce Flores and other non-citizens, quote, "cannot show that his former counsel's deficient performance deprived him of a liberty without due process," end quote. As such, he cannot bring his ineffective assistance of counsel-based challenge to the 11th Circuit. This is complicated stuff, and I'm just going to stop to note that we're even talking about due process in the Fifth Amendment, because as a civil proceeding, non-citizens don't have a Sixth Amendment right to counsel like criminal defendants do in criminal court. Now, as Petition for Review counsel noted, the 11th Circuit has reviewed ineffective assistance of counsel claims tethered to discretionary forms of relief at least 4 times in precedential decisions in the past. The panel here cast those decisions aside, however, noting that none of them expressly held that a non-citizen, quote, "has a constitutionally protected liberty interest in purely discretionary relief from a removal order," end quote. To the extent those decisions help Mr. Ponce Flores' argument, and quite frankly they do, the 11th Circuit deemed those portions dicta. Addressing the hardship challenge specifically, the 11th Circuit essentially held that Patel precludes the review, and that an argument that the BIA failed to consider all the hardship factors in the aggregate, in the way that prior precedent from the BIA requires, is no longer a cognizable argument after Patel. Rough stuff. Because the BIA held essentially that Mr. Ponce Flores didn't have a due process right to effective assistance of counsel in his application for non-LPR cancellation of removal, and because the 11th Circuit held it couldn't review the hardship issue anyway, it held that it couldn't review whether the BIA properly or improperly denied the motion to remand for the ineffective assistance of counsel. It appears that the 11th Circuit is creating an exception and will review a situation where the BIA applies an incorrect ineffective assistance of counsel prejudice analysis because it deems that a legal question that it retains jurisdiction to review. But that might be the rare case, and it wasn't at issue here. Pretty devastating holding for non-citizens all around. Naturally, I've got a bit more before we conclude. Although I admit that I'm a bit personally involved, I'm having a bit of difficulty squaring this decision. All immigration relief except withholding of removal is discretionary, but not all relief is covered by the jurisdiction stripping provision adjudicated by Patel. Namely, asylum is not. There exist quite a few 11th Circuit decisions, as well as other circuit decisions, adjudicating ineffective assistance of counsel claims in the asylum context. But if a non-citizen truly has no due process right to discretionary relief, then all of those decisions would appear wrongly decided. The 11th Circuit notes this asylum discrepancy in a footnote, but doesn't explain why that doesn't invalidate its reasoning here. Finally, this decision highlights the importance of Rekha Sharma Crawford's current campaign to get the BIA or Attorney General to either vacate matter of lazada or amend it to further explain when a bar complaint is not required and when prejudice is shown, as matter of lazada itself implies is possible. The 11th Circuit has just held that in many cases, non-citizens cannot bring ineffective assistance of counsel claims to the circuit, meaning that the BIA has the final say on many ineffective assistance of counsel arguments. If the BIA has the final say, there should be clear guidance on when ineffective assistance of counsel claims can be brought. And respectfully, we shouldn't have a situation where, unlike in every other area of law, the private bar is forced to file bar complaints against one another to advocate for their clients. And that is Ponce Flores v. Garland. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli & Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend, and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review, or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate for 5 credit hours, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all. And follow the show on Instagram and Facebook at Immigration Review, and send us a tweet at ImReview. That's IMM Review. I'll be back next Monday for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.